Every concealed carry holder in America has done it. You pull into the post office parking lot, you need to mail a package, pay a bill, pick up a certified letter. The whole errand takes 4 minutes. And you sit there for a moment because you know what is inside that building. A federal facility, a federal statute, a federal crime carrying up to 1 year in prison for possessing a firearm in a federal building. So you make the decision. You leave the gun in the car, you walk in unarmed, you do your errand, you walk back out, you get back in, and you drive away slightly more exposed than you were for the 4 minutes it took to mail a package. For decades, that was the correct decision. For decades, 18 U.S.C. C.F.R. 932A, the federal statute prohibiting firearms in federal facilities, combined with a USPS administrative regulation banning firearms on postal property, made carrying inside a post office a federal offense. Full stop. On August 12, 2026, that changed. The Department of Justice Office of Legal Counsel issued a formal memorandum opinion concluding that federal law does not criminalize carrying a firearm for self-defense inside a post office that is generally open to the public. The federal facility gun ban does not reach you. The USPS administrative regulation cannot be enforced against you. And the executive branch, the DOJ, the ATF, federal prosecutors, may not charge you for carrying in an ordinary post office for self-defense. That is the development. Now let me tell you the 3 things about this opinion that most of the coverage is getting wrong, because the difference between understanding this correctly and misunderstanding it could be the difference between a legal carry and a federal prosecution. Let me start with the 2 laws that created this problem in the first place, because you cannot understand what changed without understanding what existed. The first law is 18 U.S.C. C.F.R. 930A. Congress enacted this in 1988. It makes it a federal crime to knowingly possess a firearm or other dangerous weapon in a federal facility, defined as a building or portion thereof owned or leased by the federal government where federal employees regularly perform official duties. Post offices clearly qualify. The penalty for violating C.F.R. 930A is up to 1 year in federal prison. But buried in the same statute, in subsection D3, is an exception that has been sitting in the United States Code since 1988. That exception reads, "Nothing in this section limits the lawful carrying of firearms or other dangerous weapons in a federal facility incident to hunting or other lawful purposes." Hunting or other lawful purposes. That language has been there for 38 years. And the question nobody had definitively answered until August 12, 2026 was this: does self-defense qualify as a lawful purpose under that exception? The answer, according to the DOJ's Office of Legal Counsel, is yes. Self-defense is a paradigmatic lawful purpose. The opinion goes further. It holds that no special connection is required between the reason you enter the building and the reason you are armed. Buying stamps is a lawful reason to be in the building. Self-defense is a lawful reason to be carrying. The exception is satisfied. The 2 do not need to be linked. You do not need to be going to the post office to conduct a lawful hunt. You need to be going there for any lawful purpose and carrying for any lawful purpose. The errand and the carry are evaluated independently. The second law is the USPS's own administrative regulation at 39 C.F.R. C.F.R. 232.1L. This is a separate provision from the federal statute. It is a rule the Postal Service created for itself in 1972. It imposed a blanket prohibition on firearms on postal property except for official purposes. In 2007, USPS amended it to apply, and I want you to hear this language, notwithstanding the provisions of any other law. The Postal Service was trying to make its ban stick even against statutory exceptions. It was trying to write itself out from under the very statute that contained the lawful purposes exception. The OLC concluded that attempt failed. An agency regulation cannot override a congressional statute. The USPS does not have the legal authority to expand its administrative rule beyond what Congress authorized. When the statute says the carry restriction does not apply to lawful purposes, and the USPS regulation says it applies regardless, the statute wins. The OLC declared the USPS regulation unlawful as applied to otherwise law-abiding citizens carrying constitutionally protected firearms for self-defense in post offices open to the public. Now let me explain what this opinion is and what it is not, because this distinction is the most important thing I can tell you in this entire video. The Office of Legal Counsel is a component of the Department of Justice. It provides binding legal interpretation to the President and all executive branch agencies. An OLC opinion is the executive branch's authoritative reading of the law for itself. When the OLC says the executive branch may not enforce C.F.R. 930A against a law-abiding person carrying in a post office for self-defense, that means federal prosecutors cannot charge you. ATF ATF agents cannot arrest you. Postal inspectors cannot detain you for that conduct. The executive branch has told itself the law does not reach you. But an OLC opinion does not bind federal courts. If a prosecutor, ignoring the opinion, brought charges anyway, a federal judge would decide independently whether Taylor 930D3 covers self-defense carry. The OLC opinion would be persuasive. It would not be controlling. The judge could disagree, and an OLC opinion can be reversed by a future administration. The next DOJ under the next president can issue a new memorandum reaching the opposite conclusion. That does not require a new law. It does not require a court case. It requires a memo. One document from the next OLC reverses everything the August 12th opinion established. That is the fundamental fragility of executive branch legal opinions compared to court rulings. This is why the FPC and SAF permanent injunction matters, and why it provides something the OLC opinion does not. In September 2025, Chief U.S. District Judge Reed O'Connor of the Northern District of Texas ruled in FPC v. Blanche that the federal post office gun ban is unconstitutional as applied to members of the Firearms Policy Coalition and the Second Amendment Foundation. He issued a permanent injunction blocking enforcement against them. The DOJ appealed. The Fifth Circuit denied an emergency stay. Then, on June 25, 2026, the Supreme Court decided Woolford v. Lopez, reaffirming that laws restricting armed carry in publicly accessible spaces fall within the Second Amendment's plain text and must survive Bruin's historical analysis. 3 weeks after Woolford, the DOJ moved to voluntarily dismiss its own appeal. The Fifth Circuit granted the dismissal on July 23, 2026. O'Connor's injunction became final. 12 days later, August 12th, the OLC opinion followed. The litigation forced the DOJ's hand. Woolford confirmed the constitutional direction. The OLC opinion extended the non-enforcement position beyond FPC and SAF members to all law-abiding Americans. If you are an FPC or SAF member, you have two independent legal protections. The permanent court injunction, entered by a federal judge, survived appellate review and now final, and the OLC opinion. The injunction protects you as a matter of court-ordered law. The OLC opinion protects you as a matter of executive branch enforcement policy. One requires a new court proceeding to reverse. The other requires only a new memo. If you are not an FPC or SAF member but hold a valid carry permit, the OLC opinion establishes the federal government's non-enforcement position as to you. Federal prosecutors will not charge you for carrying in an ordinary, publicly accessible post office for self-defense. You do not have the court injunction as a backup, but the executive branch's stated interpretation of the law covers you for as long as this administration's OLC position stands. Now let me give you the 5 things this opinion does not cover, because this is where most coverage has been imprecise, and imprecision here creates real legal exposure. Federal courthouses. A separate provision of Taylor 930 governs federal courthouses. The OLC opinion addresses ordinary post offices. It does not touch federal courthouses. Carrying in a federal courthouse remains a federal crime under a separate statutory framework. Do not read this opinion as applying to any federal courthouse or any other federal building. It is specific to post offices. Restricted postal facilities. The opinion covers ordinary post offices generally open to the public. The retail counter where you buy stamps, mail packages, and pick up certified letters. It does not cover mail sorting facilities, postal processing centers, restricted postal operational infrastructure, or any postal facility that is not open to general public access. The public-facing retail space is covered. Operational postal facilities are not. Criminal intent. The OLC opinion is explicit on this point. A permit holder who walks into a post office intending to commit a crime is not protected by the lawful purposes exception. The exception protects the errand, not the crime. Self-defense is a lawful purpose. Criminal conduct is not. Section 930A still applies the moment the carry is incident to unlawful conduct. State and local law. The OLC opinion addresses federal law only. State laws restricting carry in post offices, state-level sensitive places designations, state permit requirements, and local ordinances operate entirely independently. In states where post offices are designated sensitive locations under state law, or where you do not hold a valid carry permit, the OLC opinion provides no protection. The federal ban is resolved by this opinion. Your state's law may not be. Check your state's specific carry statute and sensitive places provisions before you carry in any post office. Durability. This protection lasts as long as the current administration's OLC interpretation stands. An administration change can reverse it without legislation, without a court case, and without notice. If you want court-backed protection that survives an administration change, FPC and SAF membership provides the O'Connor injunction as an independent legal basis. That injunction cannot be reversed by a memo. Let me close with the compliance picture stated as plainly as it can be stated. If you hold a valid concealed carry permit, you are not a prohibited person, and you are in a state that permits carry. The DOJ has told you that the federal statute does not criminalize your self-defense carry in an ordinary, publicly accessible post office. Federal prosecutors will not charge you for it. The USPS regulation cannot be enforced against you for it. You still need to check your state's carry laws. You still need to confirm you are in a publicly accessible post office and not a restricted postal facility. You still need to be carrying for a lawful purpose and not incident to any criminal conduct. And you need to understand that this protection is one memo away from reversal if the administration changes. For 38 years, the lawful purposes exception sat in 18 U.S.C. C.F.R. 930D3, while millions of law-abiding Americans disarmed themselves in post office parking lots. On August 12, 2026, the Department of Justice finally read what Congress wrote in 1988 and concluded that self-defense is exactly the kind of lawful purpose the exception was designed to protect. The 4-minute post office errand just got safer. Whether that lasts depends on who runs the DOJ next.